change that soon. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2 of Jefferson County, Texas. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come here this morning for what is called an arraignment. What the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Your case is classified as a misdemeanor case. In this court, we handle Class A and Class B misdemeanors, and we also do Class C misdemeanor appeals. Your case fits in one of those three categories. The felony courts, which is down the hall, handle felony cases. Criminal cases are divided into felonies and misdemeanors. If you had a felony case, it would either be a capital murder case, first-degree felony, second-degree felony, third-degree felony, or state jail felony. And the range of punishment for a capital murder case, if a person is convicted, is life or death. If you had a first-degree felony case, the range of punishment is 5 to 99 years to life, fine up to $10,000. If you had a second-degree felony case, the range of punishment is 2 to 20 years, fine up to $10,000. Third-degree felony, range of punishment is 2 to 10 years, and a fine up to $10,000. Or if you had a state jail felony, the range of punishment is minimum 6 months in the state jail to a maximum of 2 years in the state jail, fine up to $10,000. Now, the difference between the felonies and the misdemeanor cases, for the felony cases, your punishment can require that you go to the state penitentiary. For a misdemeanor case, you cannot be sent to the state penitentiary. However, you can be sentenced to the county jail. If you have a if you have a Class A misdemeanor, the range of punishment is anywhere from 0 days in the county jail to 1 year in the county jail, which is 365 days, or anywhere in between, a fine from $0 to $4,000, or anywhere in between, or you could be given both such fine and confinement. If you have a Class B misdemeanor, the range of punishment is 0 days to 180 days, which is 6 months, or anywhere in between in the county jail. A fine from $0 to $2,000, or anywhere in between. Or you could be given jail time and a fine. If you have a Class C misdemeanor, you cannot be given jail time. A Class C misdemeanor is fine only. And the Class C misdemeanors are normally handled in our JP court, which is the justice court, or the city court, which is the municipal court. They handle Class C misdemeanors. And your Class C misdemeanors are normally your traffic tickets and cases such of that nature. You can only be given a fine, no jail time in the county. Now, the case that you have in this court is classified either as a Class A or Class B, or if you appeal the case from the JP court or the municipal court, it's a Class C misdemeanor, and the same range of punishment still applies. As a defendant in a criminal case, you have rights. Now, the first rights we're going to talk about is the one that you have on the tablet that's been handed out. As a defendant in a criminal case, you have a right to have an attorney. Now, you have three options regarding your right to have an attorney. Number one, you may hire your attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to you. Or number three, you may represent yourself. Now, if you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document, it states defendant's choice. Mark initials next to only one choice. Now, if your choice is, I want to reset this case to hire my own attorney, you will place your initials on the first line to the left. If you have already hired an attorney, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you will place your initials on the third line to the left. If you have already been appointed an attorney, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney and represent myself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign on the line where it says defendant, and you will date it today's date, December 14th of 2021. Now, for those of you who will be representing yourself, those of you who have signed on the 5th line, the second page applies to you. And the second page is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 14th day of December 2021 by the County Court at Law Number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, you will sign on the line that says defendant, and you will date it today's date, December 14th of 2021. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. That area that's over there, we call that the jury box. 6 citizens will be selected to sit on your jury. They will decide whether or not you're guilty or innocent after listening to all of the evidence. You also have a right to waive, which means to waive your right to a trial by jury, which means you have a right to give up your right to have a trial by jury. And by doing so, you will not be having a jury trial. Your case will come before the court or come before the judge in one of 2 ways. It can come before the judge by way of a trial, or it can come before the judge by way of a plea. Now, if it comes before the judge by way of a trial, we call that a bench trial. And the judge will be the judge and the jury in your case. The judge will decide whether or not you're guilty or innocent after listening to all of the evidence, and the judge will, if the judge finds you guilty, the judge will assess the punishment in your case. Now, if you enter a plea, plea is where you have reached a settlement on your case and you want to enter into what is called a plea bargain agreement. Now, if you enter a plea, that is, if you plead guilty or no contest, and you want your case to come before the court or the judge, then the judge will entertain the plea bargain agreement. For example, if you and the state have reached an agreement to settle your case, we call that a plea bargain agreement, and the court can either accept the plea bargain agreement or not accept the plea bargain agreement or reject the plea bargain agreement. Now, if the court accepts the plea bargain agreement, and if you decide that you would like to appeal the case 30 days later, you have to get permission from the court. Now, if the court rejects your plea bargain agreement, then you can simply withdraw, which means you can simply take back your plea of either guilty or no contest. Now, pleas, a person can enter one of three types of pleas. They can enter a plea of guilty, not guilty, or no contest. If a person enter a plea of guilty, they're saying they committed the offense that they've been charged with. Now, if they say they did not commit the offense, they enter a plea of not guilty, they're saying they didn't commit the offense. Or if they enter a plea of no contest, they're saying to the court, I will not be fighting the charges against me. Now, I mentioned to you that you can come before the court either by way of a bench trial, or you can come before the court by way of an agreed plea bargain. You can also come before the court by way of an unagreed plea bargain. What that means is this here: you and the state have not reached an agreement. However, you still want to enter your plea and you want the judge to assess the punishment. We haven't agreed, but I want the judge to assess the punishment. We call that an unagreed plea bargain. Now, you also have a right to have witnesses in your case. That area over there, that chair, we call that the witness stand. Witnesses, they testify for you, against you. You could ask them questions. We call that direct examination or cross-examination. You could either ask them questions either by direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses to come in court, to testify in your case. And by doing so, you will not be calling witnesses. However, the state, which is the state of Texas or the district attorney's office, will be calling witnesses in their case or in your case. Now, you also have a right to have what is called discovery. Discovery is you have a right to see the evidence that the state has against you in your case. In essence, you have a right to see the documents, the videos, the witness statements, etc. You have a right to have access to that. We call that discovery. Now, you can waive your right to discovery, which means you can waive or give up your right to see the evidence that the state has against you. Now, going back to witnesses in your case, now you have a right against self-incrimination. We call that the Fifth Amendment right against self-incrimination. What that means is you have a right not to testify in your case. Now, if you want to testify, you'll be waiving your right. In essence, you'll be giving up your right not to testify to testify. Okay, so you'll be giving up your right against self-incrimination, and you'll be saying to the court that you would like to testify in your case. Now, Jefferson County, Jefferson County District Attorney's Office has a program that is called pretrial diversion. That is a program for first-time offenders. And if a person is accepted into that program, then your case is dismissed and you can get it expunged. Expunged means erased, deleted, or wiped off from your criminal record. Now, in order to qualify for that program, it has to be your first case. In essence, you cannot have a criminal record. You have to have an attorney to assist you at helping you to get into the program. And your offense cannot be unlawfully carrying a weapon or resisting arrest. So if you have any other offense, you may qualify. So, and as I said earlier, if you get into the program, the case is dismissed, you complete the program, you can get it expunged from your record. Now, also, you'll have some options here in your case. As I said earlier, you have an option to either plead not guilty, guilty, or no contest. Now, everyone here has been arrested on their case. In essence, you was arrested, put in jail, you bonded out. Either you on a cash bond, a surety bond, or a PR bond. In any rate, you are out on bond. Now, every day that you spent in jail, you will get credit, for example, that will go towards your punishment. So for example, let's say you and the state, y'all reached a plea bargain agreement, and let's say you spent 5 days in jail, and let's say the state say, okay, we're gonna, our plea bargain agreement is for you to serve 5 days in jail. What that basically means is you would not have to serve any more time in jail. Why? Because you've already served 5 days in jail. Therefore, you'd be given credit for the time that you already served in jail. So you'd be given what is called credit for time served. Now, if they say, well, our plea bargain is for 6 days and you serve 5, then that means you have to serve 1. Now, let's say the state is offering you a fine and court costs in this case. And every day that you spent in jail, you get credit at $100 per day. So if you spent 5 days in jail, that's $500. And so if the state says, okay, we want you to pay a fine and court costs, which equals $500, and you spent 5 days in jail, that simply means you won't have to spend no money, because the 5 days in jail will be applied to the fine and court costs, which means that you'll be given credit toward that, and then the fine and court costs will be taxed and retired. In essence, you won't have to pay it. Now, if they say, no, the fine and court cost is $600, that means you would have to pay $100, because you already have credit for $500 for the 5 days that you spent in jail. Now, let's say you can't pay the $100. Then if you can't pay the $100, then because you're indigent, then what can happen is we can convert the fine, the $100 to community service, okay? Which means you'll work it off, and you'll get $12.50 for every hour that you work. So if you work an 8-hour day, that's $100. And so now, so those are the things that we can do to assist you, and it's basically in the Code of Criminal Procedure that allows you to satisfy your punishment either by jail time or fine or by community service, or it could be a combination of both. Okay. Now, as I said earlier, Jefferson County has a program that is called pretrial diversion, and with that program, if you get into the program, your case is dismissed, and you can get it expunged from your record. Now, Jefferson County also has a program that is called Veterans Court. It's also under the pretrial diversion program. Veterans Court basically is for veterans. If you are a veteran of any one of the branches of the United States military, you may qualify for Veterans Court. And if you get into the Veterans Court, your case is dismissed. And you complete the program, you can have it expunged, which means erased, deleted, or wiped off from your record. And so that program is for veterans. Only thing you have to do is be a veteran of any one of the branches of the United States military in order to qualify to get into that program. Now, this court, County Court at Law Number 2, has a program that is called the Community Safety Initiative, commonly referred to as the CSI program. It's a program that I started in March of 2017. So we've been doing this for over 4 years. And that program is designed to address the issue of what we call recidivism. Recidivism, where people commit crimes over and over. You know, they commit one crime and another one eventually. And eventually they graduate from misdemeanor court to felony court. And so to address the issue of recidivism, I started the Csi program, and that program is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, go to church. Now, the way the program works is we have partnerships with agencies in our community. We have a partnership with our local Spindletop Center. Spindletop is our local mental health agency. And we have individuals in the courtroom, mental health officers, counselors as well, who can do what we call a private interview. Spindletop can do an assessment. They can develop a treatment plan, either outpatient or inpatient, to address your mental health needs. Now, when I say to address your mental health needs, you don't have to be insane or incompetent, okay? The program is designed for people who have, say if you're depressed, you suffer from depression, post-traumatic stress, it could be ADHD, it could be paranoid schizophrenia, post-traumatic stress, you could be bipolar, just a whole host of other mental illnesses that you may have. They can address those in the program, and they can meet your mental health needs. Also, for individuals who have issues with drugs or alcohol, Spindletop has a program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. That is a program where individuals can be given a screening, an interview, a treatment plan also could be developed for you as well, either outpatient or inpatient. Now, we also work with Ozar, which is a local mental health agency in the area as well. They can do screenings, treatment plans as well to assist your needs with drugs or alcohol. Now, if you are unemployed or if you are looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once individuals assign in one of the areas that they choose, they will assist you at getting a job in those areas that you're trained in. Now, if you have not graduated from high school and you want to get a GED, they also have a program for individuals to assist individuals to get a GED. Now, all of these programs that I have just mentioned to you are free. It does not cost you anything, does not cost the county anything as well. And only thing you have to do is have a desire to be in the program in order to get into one of the areas that you need to be in, or you can get into more than one of the areas that you need to be in. Now, these programs, I say this all the time, when you come to county court at law number 2, we don't have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And we're trying to make a difference in Jefferson County, the community in which we live. All of these problems, all of these programs that we have are designed not to just arrest the problem, but it's designed to address the problem. I tell people this all the time. We do not just give time, we take our time. And we take our time to address your needs so that you can become a productive person in our community. And we believe that productive people do not commit crimes because they have too much to lose. And so, only thing, as I said earlier, if you want to be in any one of the programs or combination of more than one of the programs, just let us know and we'll be happy to assist you. Now, we have some individuals in court today who is from Spindletop. We're going to have either Jess or Mr. Hinton to come forward and tell you something about the Spindletop program. So who's gonna, Deputy Hinton? So we're gonna have Deputy Hinton who's gonna come forward. He's gonna tell you something about the Spindletop program. Deputy Hinton.
Thank you, Your Honor. That's it. My name is Steve Hinton. I'm a mental health deputy with Jefferson County Sheriff's Office, also licensed by the state of Texas. I'm here with my partner, Jess Hebert. He is a qualified mental health professional with Spindletop. The reason we are here is because the judge graciously allows this courtroom because he cares about every single person who comes before his court. And what the judge has found is people who commonly come before his court either have mental health or substance use disorders, which cause some of their legal issues. If this applies to you, the judge believes if we can address these underlying issues, we can get you out of the cycle of arrest. Whether this be your first time or your 10th time, there are services for you that can help you. But it's going to take a couple of things. First of all, we don't know if we don't ask. So that's what we're doing this morning. We're asking you if this is something that's going on with you that's causing your legal issues. And we don't know if you don't tell us. We're asking you to share that with us this morning. As the court goes into recess, we'll be visiting with you individually. We'll give you an opportunity to speak privately. We're not here to embarrass anyone. It's not about that. Your information is HIPAA regulated. It's only going to be between us and who you allow permission to hear or know about it. May be involved in your treatment or whatever else, but it's all going to be dependent upon you. It all boils down to decisions. You have decisions to make. Today is going to be a decision concerning this situation here. At the very least, I want to give you this brochure. It has our information on there. It has a 1-800 number crisis hotline number on there. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. In the interim, if you're not in crisis, then you have another number that you can call there and we will be glad to assist you. We also will be glad to visit with you one-on-one today if that's something you're interested in. If this doesn't apply to you, maybe it applies to a family member or a friend, we'll be glad to still get this information to you so that you can take this to those people and we can help those people as well if this is something that you're interested in. I appreciate your attention. Thank you for very kind. Thank you, Your Honor.
Okay, thank you, Deputy Hinton. Now, ladies and gentlemen, the paperwork that has been handed out, we're going to come by, pick that paperwork up. Now, it's going to take us a little time to go over the paperwork, and we're going to put you in, I guess, different categories. So at this time, the court is going to be in recess, and our staff, if anybody needed some help, we have our staff here who will be happy to help you